Excellent. Cool. So good morning, everybody. Thanks for joining us for the webinar today. We'll be covering off, say, the key impacts of the Employment Rights Bill for SME businesses. I'm Dan, Managing Director here at Riverview Portfolio, and I'm delighted to be joined today by Helen and Emma from the HR Dept Swindon, who will be leading our webinar today. Before we get started, I just want to run through some housekeeping bits. We want the webinar to be as interactive as possible. So if you do have questions, things that come up, you will find at the bottom, if you're used to Zoom, there is the Q&A function. I believe that the chat function is also open. I'll just be keeping an eye on that, so not to ruin Helen and Emma's flow on stuff. So say if you've got questions as they come along, please do drop them in there and we'll try and weave them into the presentation as we can do. There will be a recording of the webinar that will be available after, so Joe will get that prepared. And what we'll have is that we'll share that with people that have registered, but also make it available on our YouTube channel as well. As always, we'd love to hear your feedback. So if there are future topics that you want covered off or anything that Helen and Emma go through today that you might want covered off in more detail, I'm sure, and I'm not speaking too apart on their behalf, that they'll be more than happy to sort of go through any bits that sort of come up from it as well. Just to let you know, we do have another webinar already lined up next month on Wednesday, the 26th of November, which will be following the budget announcements. So again, there might be further things that affect what we're talking about today, but obviously also the financial pieces as well. So I will share with you a link if you want to get an early registration on that. That will be, I believe, at 4 o'clock on that Wednesday following the budget. So let's see what comes out of that. So I think that covers everything from a housekeeping point of view. As I said, any questions, please do just drop them in the thing. So without further ado, I will hand you over to Helen and Emma, who will lead on today's topic.
Brilliant. Well, thanks so much for that lovely introduction, Dan. And yeah, as I said, me and Emma are very happy to be here to speak to you all about some of the key changes that are coming and the impact that might be affecting your businesses. So I'm just going to share my screen a second, so just bear with me. So hopefully you can all see that. Yeah.
Yep.
Perfect. Okay, so what are we going to be talking about today? So the first thing we're going to do is just provide an overview of the Employment Rights Bill, the kind of the key kind of purpose behind it, what it's trying to achieve, and then we'll go into a bit more of a deeper dive in terms of what those changes are. Look at the key changes specifically for SMEs. So there are some parts to the Employment Rights Bill that might not be applicable to your business. So we're going to focus specifically on those key changes which might affect you. We're also going to talk about what can you be doing now. So obviously there's still a lot of detail which we're still waiting for, but there are steps you can be taking proactively, or at least be considering or factoring in terms of your future planning for your business. So we can give you some hints and tips on what you could be doing. What could change? So where we are right now, we're still in the ping pong stage of that bill between kind of Parliament, the House of Lords. Things could change when we come to looking at, you know, the secondary regulations which might be supporting the actual kind of changes that are coming in. We'll also be going through kind of a timeline of the changes of when you can expect certain parts of that bill to be coming into force, and that will again help you with your planning. We'll also be covering how we can help. Obviously, we are kind of employment specialists, so you know there are things that we can do as well. If you need additional support with anything, we know we're here to help. So the first thing I'm going to go through is kind of introducing the bill and what its purpose is and the key areas that you need to be aware of. So the whole point of the Employment Rights Bill, it came out of the plan to make work pay developed by the Labour Party's manifesto commitment. And it's designed to help more people stay in work, support worker productivity and improve living standards. this bill is the first kind of significant delivery vehicle of that plan. And it represents probably the biggest upgrade in employment rights since the 1990s. So in terms of the key areas that the bill is trying to address, one is about one-sided flexibility. So they're saying that the employers have too much flexibility on their side, and employees also need to, that needs to be shared, and that needs to be distributed more evenly. They want to ensure that workers are getting fair pay. They're prioritising equality and well-being for workers. They're also looking to modernise trade union legislation and generally just improving enforcement of employment rights. So let's break it down into a bit more detail. Well, what does that actually mean in terms of how does that link with the purpose and actually the changes that are being proposed? So when we're talking kind of about one-sided flexibility, the things we're talking about there are about ending zero-hour contracts, ending fire and rehire, removing the 2-year qualifying period for employment for unfair dismissal claims, and strengthening collective redundancy rights. In terms of the fair pay aspects, that's linked to strengthening SSP and strengthening tipping laws. There's a family-friendly element to this as well, where we'll be looking at day one rights for paternity leave and parental leave, unpaid bereavement leave. There's going to be more protections for pregnancy and maternity rights, and increased kind of focus on flexible working. In terms of fairness, equality and wellbeing, we'll be looking at sexual harassment and third-party harassment and taking all reasonable steps to try and address those. Whistleblowing, again, we're looking at increased protections for sexual harassment, being a protected disclosure, and gender equality, which is mainly going to be affecting kind of larger organisations. With enforcement, there's the establishment of this Fair Work Agency and the tribunal claims extending the deadline for that as well. There's a whole host of trade union changes that are going to be coming in, which includes repealing the existing legislation, increasing the rights to access, the recognition, trade union reps, and the duty to inform from an employer to the employee as well, which is obviously is a change. So then we're thinking about, okay, well, that's a whole host of things. What are the key changes for businesses, for SMEs, that really we need to be aware of right now, and what could have possibly the biggest impact? So the first one is day one unfair dismissal rights. Now, it's going to limit the ability for companies to deal more robustly with shorter serving employees. So if you've got a performance, a conduct issue, at the moment, employers have the ability to follow much shorter processes to deal with those issues without any fear of potential unfair dismissal claims. That's going to change. And so that's going to have a big impact on that. And we'll cover off things you need to be thinking about how to address that as well. So there are steps you can be taking, to deal with the changes. The changes to 0 hours and agency contracts. So this is talking about the right to guaranteed hours. So there's going to be more of an emphasis on employer recording of hours and basically being more proactive to manage workers on those types of contracts. The next one is SSP from the first day of absence. So at the moment, we have those 3 waiting days before SSP kicks in. That's going to be removed. And in addition, there's also going to be a removal of the lower earning limit. So more people are going to be eligible for that. Banning fire and rehire processes. So this is where you can't agree terms, and so you essentially dismiss them and try and re-engage them on new terms. That's going to be basically automatically unfair if you try to do that. It's much more of a move towards kind of getting that collective agreement with employees to change terms. There's going to be increased obligations for preventing harassment. So this is again taking a further step forward from what came in kind of this time last year in terms of sexual harassment obligations, and that includes obviously the third-party harassment as well. And obviously with the extension of the tribunal claim limits, that's going to obviously have an impact because people have more time from, you know, when the issue happened to try and make claims at tribunal. So there are, as I said, there are a lot of changes coming in. A lot of the detail we don't have necessarily access to right now. There's a period of consultation and, as I said, secondary legislation to come in to kind of reinforce all of that. But I'm going to hand over now to my colleague Emma, who's our employment relations specialist, who's going to take a bit more of a deeper dive into these areas and what we know, what we don't know, and potentially then we'll cover off what could potentially change as well.
Lovely, thank you, Helen. So now let's look at one of the most significant changes in the Employment Rights Bill is day one rights for unfair dismissal, essentially removing the 2-year buffer that businesses currently have before employees can claim. So what do we know? First, the government has confirmed that a consultation will take place during summer and autumn of 2025. This will be crucial because it will shape how these rights are implemented in practice. Interestingly, the House of Lords attempted to amend the bill to introduce a 6-month qualifying period before these rights kick in. That amendment didn't pass, but it shows that there's still debate about how quickly these protections should apply. At the moment, the expectation is that there will be an initial period of employment, likely to be around 9 months, where dismissal processes will have a lighter touch. What does lighter touch mean? So, well, the consultation and subsequent regulations will define exactly what that lighter touch looks like, but it could involve simplified procedures or reduced obligations for employers during the initial phase. In short, the principle of day one rights is clear, but the practical details, particularly around the lighter touch, are still being worked out. What this means is that hiring decisions have already become more critical. Given we're expecting this change to be implemented in 2027, every new hire that you make now will not have the full 2-year waiting period before they can make unfair dismissal claims. So at this time, you'd be looking to ensure you're utilising your probationary periods now to allow you to assess new hires fairly, while also providing you with a safety net should they not be the right fit. These processes will also likely be part of the initial period of employment, so starting to build the good habit and build these into your employment ongoing at the moment now is a good idea. Okay. So let's talk about 0-hour and agency contracts. This is another area where big changes are coming. So the expectation is that workers will gain a right to guaranteed hours after a reference period. Right now, that reference period is being discussed at 12 weeks. So if someone has been working regularly for 3 months, they could request a contract that reflects those hours rather than staying on a 0-hour arrangement. Another important point is that employers may become liable for payment if they cancel or shorten shifts within a certain time frame. This is designed to give workers more security and reduce last-minute cancellations that leave people out of pocket. Finally, the detail on this will come through on a consultation plan for autumn 2025. That will clarify how guaranteed hours will work, what the cancellation rules look like, and whether there will be any exceptions for certain industries. Again, the principle is clear, ultimately more stability for workers, but the practical rules are still to be defined. Employers should start thinking now about how this could impact scheduling and workforce planning. It's going to particularly impact industries such as hospitality. Okay, so moving on to statutory sick pay. So this is where another big change is coming in under the Employment Rights Bill. So currently employees have to wait 3 qualifying days before they qualify for SSP. Under the Employment Rights Bill, that waiting period is going to be removed. So employees will be entitled to sick pay from the very first day of absence. In addition, the lower earnings limit will be scrapped. This means that all employees, regardless of how much they earn, will be entitled to receive statutory sick pay. Now that's a big shift, especially for for lower paid or part-time workers who previously didn't qualify as they fell below the threshold. This change could see an increase in absence levels and potentially disguised absence from unpaid leave, such as dependence or bereavement or other reasons. So the overall aim here is to make sick pay more inclusive and immediate, reducing financial pressure on employees when they're unwell. For employers, this could mean reviewing payroll processes and budgeting for potentially higher SSP costs. So another headline change is the government's plan to ban the practice of fire and rehire, and it will become automatically unfair dismissal in most cases. So this is where employers dismiss staff and then re-engage them on new terms, often less favourable, to push through contractual changes. So this move is aimed at protecting employees from being forced into accepting worse conditions under the threat of losing their job. The intention is clear again, the practice will no longer be allowed. However, the detail on how this ban will work in practice is still to come in. A consultation is scheduled for autumn 2025, and that will define the scope of the ban, any exceptions, and what enforcement will look like. For employers, this means the traditional approach to restructuring or changing terms will need to be revisited. Alternative strategies such as negotiation or collective consultation will become even more important. So this part of the Employment Rights Bill introduces a proactive duty on employers to prevent sexual harassment and harassment in the workplace in general. Currently, the law focuses on responding to harassment after it happens. The new approach is shifting responsibility to prevention. Employers will need to take all reasonable steps to stop harassment before it occurs. This means policies, training, and culture will become a critical compliance area. There's also a new obligation to prevent sexual harassment by third parties. So for example, customers, clients, or contractors. This is significant because it extends the employer responsibility beyond their own workforce. So in 2027, the government will introduce regulations to define what counts as reasonable steps. Until then, we know the principle, but again, not the detail. This could include things such as mandatory training, clear reporting channels, and regular risk assessments. For employers, this means preparing now, reviewing anti-harassment policies, considering staff training, and thinking about how you can manage third-party interactions. So the next change we'll cover today relates to employment tribunal time limits. So currently the standard time limit for most claims, such as unfair dismissal or discrimination, is 3 months from the date of the alleged incident. Under the Employment Rights Bill, that window will be doubled to 6 months. Why is that significant? Well, first, it gives employees more breathing space to seek advice and potentially prepare their case. This will likely result in more claims being filed because the pressure of a short deadline will be reduced. For employers, this means 2 things. Greater exposure to litigation risks, so disputes could resurface months after you thought that they were resolved, and record keeping becomes critical. So you'll need to maintain detailed documentation for longer periods to defend claims effectively. This is a significant extension and is expected to lead to an increase in claims being brought against employers. And ultimately, this change could add pressure to an already stretched tribunal system. So delays in hearings may become more common, and we're seeing them a lot already at this time. And then finally, let's...
Emma, if I could just,
yeah.
There's a question that came through which links to the tribunal stuff about, I guess really like with a lot of these changes, people are also thinking about what protection is there for the employer.
Yeah.
So it's around like, the question that's come through is around support for employers in seeing that it's legitimate in terms of the claims that are being made, and if there's like an earlier cut-off point, like in terms of being able to manage that situation if a tribunal claim does come up.
So as if a claim came up for you to be able to defend it?
Yeah, and I guess, like I said, the protection side for the employer in terms of the legitimateness of it, like
yeah,
when we come through, like what do employers need to be aware of to protect their position?
Yeah, so I think ultimately you're going to need to be aware of any potential risk factors in a case that may come up. So making sure that whatever that case is, that you're acting reasonably, that you're ensuring that you're acting in compliance with employment law, and that you've kept a good audit of any conversations that have happened or any steps that you've taken. As anything, there's always a period of time where there will be in a process. So if we're talking at like an appeal or a grievance, there will be a grievance hearing, there would potentially be an appeal, and then you would, before you even get to tribunal stage. So there's time to be able to kind of review those processes, but ultimately it's about being aware of the risk factors, being aware of the employment law and any potential risk to that. Helen, anything to add?
Yeah, I would just probably add to that it's important to note that if anybody does want to make a claim, then they do have to go through ACAS early conciliation. So that is a kind of pre-tribunal step where you can try to address that claim essentially before it becomes a claim at a tribunal, and an employee has to go through that. It's like a mandatory process before, it's usually about a 6-week period. And that's when ACAS will then try to facilitate agreement to try and between the employer and the employee to basically try and limit any claims going through to tribunal. So there's a pre-tribunal stage where, so it's important not to kind of panic because you've got that stage and you'll be notified of that. If they make a claim through ACAS early conciliation, the employer is notified, and at that point you can decide whether you want to engage in that, to find out what they're claiming, what they're looking for. Is it something that you've identified might be a risk, and actually you might be better off trying to settle it at that stage before it goes to tribunal? Or you could potentially say, well, actually, we don't think that this kind of claim has any merit, and that could be your response back, and then you can just wait and see if they make a claim at tribunal. So there are steps kind of before a tribunal stage that you have to kind of engage with that employee to seek what their claims are and what they're looking for, and trying to resolve it before it gets to the ET stage. Obviously, once they've got that certificate, all that does is provide them the ability to raise that claim at the employment tribunal. It doesn't necessarily mean that you can't engage with utilising ACAS as well to try to resolve that before you get to kind of a final hearing. Once it gets to the final hearing stage, then at that point kind of settlements are off the table as such. That's going to proceed, but there's many steps, and that stage of the tribunal, you have a preliminary hearing where kind of people have to put forward their case, and certain evidence will have to be collated, and that will have to be shared between the parties as well to get an idea. So there's many stages before you get to the kind of final hearing, before it's kind of a judge is making a final decision on anything. So even if you do get a claim, kind of don't despair. I guess there are things that you can be doing as well to and if you're confident in your position, you've got a good audit trail, you've done all of the right things, you've used all of your internal processes, that's only going to benefit you when it comes to that stage as well.
Cool, thank you.
Lovely. So back to the slides then. So finally, let's quickly look at some additional changes that are part of the Employment Rights Bill. They may not have grabbed the kind of headlines, but they're equally important for employers to be aware of. So first, we have the Fair Work Agency. So this is expected to launch in April 2026. So this body will oversee enforcement of employment rights and could play a key role in compliance monitoring. Next is day one paternity and parental leave will come into effect around April 2026. So this will give new parents immediate access to these entitlements without any qualifying period. The qualifying period is currently in place. We'll also see an extension of bereavement leave to employees without dependents. This is expected in 2027 following consultation in autumn 25. Another major shift is flexible working becoming the default by 2027. So this means employers will need strong processes for handling flexible working requests and potentially redesigning roles. On collective redundancy, so expect a new threshold for consultation and a doubling of protective awards. So these changes will roll out across 26 and 2027 with consultation in early next year. This will make compliance in redundancy situations more complex and costly if mishandled. There will also be enhanced rights for pregnant workers, which is expected in 2027, and a series of trade union related changes phased over the next 2 years, which could increase union access and influence within the workplace. So that's kind of covered some of the detail of the upcoming changes that we're expected to see as part of the Employment Rights Bill. So I will hand back to Helen now to cover what implementation can look like within your business.
That's great. Thank you very much. So what is our key message here? I think our key takeaway from this today is we're saying don't be scared. We appreciate there's a lot of changes. There is a lot of things going on. There's a lot of moving parts. There's a lot of details that we still don't know. But the key thing is you can be prepared for these changes. You've got some time, so as you see, some of those changes aren't coming into 2027. So you've got time to really think about, okay, well, I know this is coming. And obviously once you've got the detail, then you can look at a bit more kind of how you're going to kind of implement that. But I just want you to kind of don't be afraid of what's happening. Yes, it's a big shift, but there are things and steps that you can take. And what we're going to do now is really delve into kind of 4 main areas of actions that you can look to future-proof your business. So the first one relates to your hiring processes. So ensuring you're hiring the correct people is going to be crucial. With the changes in unfair dismissal, length of service rights, it means it's more important than ever for employers to get your hiring process as robust as possible. So, well, what do you mean by that? So there are things that we suggest you start looking at now. So think about, how are you recruiting? What resource may you have internally, which can be upskilled, for example, rather than going to a kind of unknown external person. What kind of pool of candidates are you trying to find? Making sure that you're developing accurate job descriptions and job specifications to identify what the individual will be doing and ensuring that it sufficiently covers the skills and experiences needed for that role. Think about advertising, ensuring you've got transparent adverts, making sure that roles are as attractive as possible so you're gaining the highest quality of candidates that are applying for that. Making sure you're utilising kind of screening and shortlisting processes as well, and doing that, so you can kind of get on the front foot a little bit with that. Making sure you're creating objective shortlist criteria to demonstrate fairness in the process and ensuring obviously only the highest scoring that are kind of coming in front of you. Making sure you're doing good quality interviews. Make sure that those managers that are doing those interviews are trained in how to do interviews. That that is a skill set that not all managers may have. Making sure that more than one person is involved in that process. So we always recommend at least 2 people are involved in an interview, so that you get 2 different kind of viewpoints. You've got someone taking notes, so that's accurate, reflective, and when you come to scoring those answers, then you're doing it in a fair way. And using kind of objective questions relevant to that job role. So for every interview, those questions should be very, very specific to that role and what the skills and experience is needed. And don't be afraid to say no. I personally have had to deal with hiring staff into my team. And if you're not 100% certain that the candidate is going to meet or match your criteria, don't be afraid to say, we didn't get it right this first time. Let's have another go around to see if there's any other candidates that might be better suited for that role. It's better to use that time to find the right person than wasting time later on, having to invest in managing someone's conduct or performance. Make sure you do referencing. It's seen as a bit of a tick box exercise these days, but verifying someone's employment information can be useful. And we do have instances where you know, everything looks great, you know, employers reach out for references. It might be the previous employer refuses to give a reference. Rather than give a bad reference, they'll just say, oh no, or just ignore it. That could be an indicator that something else is going on. So that whole hiring process, making sure you are finding the right person from the outset, can really help mitigate the need to try and manage, you know, shorter serving employees, especially with obviously the changes coming in for unfair dismissal rights. And although there's probably going to be a lighter touch involved, it's still probably going to be more involved than required right now. Okay. So make sure you're accurately recording absences and keeping the employees' files updated. So, you know, as a HR professional, we always like to record data. We like to have an audit trail, and we actively encourage you to do that anyway. But with the changes, if you aren't already, make sure you're putting in place mechanisms to support the accurate record keeping. And this doesn't need to be too, you know, elaborate. It could just be a simple spreadsheet. Or you could decide, actually, I'm going to invest in a HR information system. They don't have to be expensive. And there are kind of information systems out there which are specifically targeted to SMEs. And they're a useful tool to keep a record of everything. You can keep documentation there. You can keep absence data there. You can, you know, upload you know, return to works, fit notes, all of those things to those absence records. So again, you're creating this really lovely audit trail if you ever need to refer back to things, or if you ever need to take any steps to address issues like absence. You've got everything there and you're raring to go with it. So essentially, yes, the benefits of absence record keeping, you know, making sure, you know, you're being compliant legally. You know, there are requirements, you know, in terms of GDPR, in terms of dealing with kind of processing sensitive health information. So by having those mechanisms in place, you're going to be complying with that. As I said, having records can help identify patterns and trends in absence. So it enables you to deal with the root causes much earlier, rather than waiting and going, well, actually, this person's absence has been a problem for 2 years. Well, actually, that's kind of far too late. You really should be addressing it much earlier than that. And that will help you also make informed decisions in terms of what to do in terms of next steps. In terms of the financial piece, keeping that absence data helps you calculate the cost of the absence to your business. So that can also link in with kind of budgeting as well, because there are going to be financial implications as a result of the Employment's Right Bill. It also means that you're going to be treating people fairly. So keeping the records mean that you can obviously evidence that everyone, you know, you're keeping records for everybody. Everyone's being treated in a fair and consistent manner. And in terms of, you know, if you do have kind of disabilities to factor into those absences, you know, you can demonstrate, okay, it might be that you have trigger points, or you have Bradford factor scoring to manage short-term absences. Well, you know, we obviously recommend you discount disabilities in regards to that. But by keeping those records, you can demonstrate that you're doing those things. From a health and safety point of view, recording the absence data is a way to identify potential hazards in the workplace. For example, if you're seeing the same types of issues coming up time and time again, that again could be an early warning sign to you. Say, oh, wait a minute, this is not the first time we've had this issue with somebody at work. Maybe there's something that we need to look into a bit more detail and investigate. And it also makes an employee feel supported. So and accountable. So if you've got those recording, you're making them complete self-certification forms, that you're doing those return to work interviews, that they're being accountable for their sickness absence, but also there's an opportunity for those supportive discussions to take place to find out, okay, well, what do we need to know about your health? How does it impact you at work? How can we get you back to work? What steps do we need to take to support you? Making sure that you know, if they've got a fit note, for example, you can log that and talk about maybe some recommendations that are on the fit note, and then you can all just follow it through. So there's lots of different benefits of recording that data, and although it might seem like, oh, I need another spreadsheet, oh, I need another thing, and it is work to keep it maintained, that there's many benefits of doing that, and obviously we recommend that you do. So the next part is about budgeting. There are going to be additional costs, as I say. So, for example, with SSP becoming a day one right, you're going to be paying out potentially more SSP. One of the suggestions we would have would be to look at your historical absence data, because that's usually the best way of identifying what future trends might be. And you can then build those into your budgeting process. There's also, think about training. So managers with for example, dealing with flexible working, or they're dealing with the requests for paternity, etc., sexual harassment, being able to identify that. What does the reasonable steps look like? Investing in training for your managers is going to be really important. That does come at additional costs, and there's lots of different methods of doing that. So it could be that you're implementing some e-learning. You could be, sending them on external courses. You might be looking at something a bit more bespoke. So definitely think about what training, what your current capabilities are within your management team at the moment, what additional training might be useful, and how is going to be best to kind of deliver that to them. In terms of risk assessment, so with the sexual harassment points, it's recommended you do a risk assessment to highlight any potential risks, and then you can demonstrate how you're going to be kind of mitigating those, and again, taking all reasonable steps to protect staff from that. And the next big thing is in terms of your documentation, essentially. So when we're talking about that, we're talking about your contracts of employment, we're talking about your handbook or policies. Take time to review those to make sure that they are up to date with the changes in the legislation. So you're going to need to update, come April 2026, you're going to be updating your absence policy in terms of, the SSP changes. Again, you might want to double check your contract. Say, does it specify in your contract about SSP and the waiting days? Some do, some don't. So think about all of the different kind of documentation you need to review and how you can incorporate those changes, because they're coming in kind of milestones, and I'll go into a bit more detail about that now. So we've talked a lot about what the changes are, what they mean, but when are they coming? So the first kind of real milestone is about the royal assent, and that's when it becomes law. So immediately is going to be the trade union, a wrath of trade union stuff. So that will be various rules being repealed or amended to make them simpler to organise action and provide further protection for those taking that action. Then we've got April 2026, which is when obviously SSP is coming, when we're talking about collective redundancy protective awards being doubled, the day one paternity and unpaid parental leave, the establishment of the Fair Work Agency, and whistleblowing protections. Then we've got another set wrath coming in October next year, which is the banning of the fire and rehire, tightening up of the tipping laws, increased employer requirements and obligations relating to sexual and third-party harassment, extension of the employment tribunal limits. And then in 2027, we've got rights for the pregnant mothers, flexible working, collective redundancy consultation thresholds changing, bereavement leave, the day one unfair dismissal rights, and the banning of 0-hour and agency workers. So that's kind of what it looks like and what's kind of planned out. But where are we now? So essentially we are in the final stages in Parliament. So on the 15th of September, MPs considered the amendments made by the House of Lords. The government's technical changes were approved, while the non-government amendments, including proposals for the 6-month qualifying period for unfair dismissal and a diluted right to guaranteed hours, were rejected. With those issues now resolved, the bill is now on track to become law in the near future. So the House of Lords are scheduled to consider the draft bill on the 28th of October. The bill will then receive royal assent around the beginning of November. And then we're looking at kind of implementing that through 2026 and 2027, as we've previously outlined. As Emma's mentioned, the government has signalled an ambitious programme of consultations in autumn 2025, and that will be covering day one unfair dismissal rights, fire and rehire reform, and some of the trade union measures. There has been obviously changes in the cabinet because Angela Rayner was this was her manifesto, her thing to move forward. Will that actually affect anything? Unlikely to. It may be that the roadmap for consultation and secondary legislation, you know, the pace of that may change, but the roadmap is already there. So we don't believe that that's going to have any significant impact, really. So could anything change? Well, as we said, with key consultations, they could change how they look once they reach regulation stage. So when we're talking about regulations, that's about, okay, we know what the fundamental foundation changes are. It's about how it's all going to work. So for example, if you're talking about SSP, we don't know the detail of, okay, well, what happens when someone's already on sick leave, for example, how do we manage that? All of those details that employers need to actually kind of affect those changes. And other consultations could enhance or reduce the impact of some of the changes, such as bereavement leave, flexible working, and pregnant worker rights. Essentially, what we're saying is anything is possible, and you know, keep your eyes and minds open, be prepared to pivot, be agile, because you know, we don't know, as I said, all of the detail right now, so things could change. So that's really kind of the key.
Helen,
yes.
Emma, we had a few questions coming.
Sure, no problem.
So if I run through them, maybe I'll gather them so that the participants know them. So one of the things that you brought up was around responsibility on the employer on third-party relationships, mainly around the like sexual harassment piece and so on. So I know that was something that looked like it was coming in, was it October next year? I think it was on that timeline that you gave. So what should employers sort of be aware of, or maybe actioning now to try and limit effect as we get nearer to that deadline?
Helen, do you want to take this one?
Yeah.
Yeah. So I think right now, what I'd be looking at is what the risks may be. So we touched on kind of risk assessment. So I'd be taking a view of what your business is, what are the interactions to potential third parties, and what are any risks there. So if for example, your employees are estate agents and they go into people's homes, actually, is there a risk that they are alone with a third party and therefore there's a risk factor there? Is it that clients come into your place of work? So what's the risk of kind of any instances happening in that scenario? So I think there is obviously a broadening of the preventions that an employer is expected to undertake, and that does now include third party. So I think it's about, at this stage, conducting risk assessments, looking at any opportunities and where processes may be able to be a bit more robust. What's the training? What's the reporting of any potential harassment scenarios? And again, just picking up the risks and how they might be mitigated. So if it is going alone into an environment with a third party, what's the reporting procedures when they arrive or when they leave, or do they have alarms when they're there? Those kind of things.
Yeah, cool. Yeah, next one was around employers employing foreign nationals that aren't based in the UK. Is it same rules that are applying to them as they would do to a UK-based employee.
So if they're employed by a UK
They'd be employed by a
employer,
UK-based business, yeah.
then yeah, they would follow the UK legislation and laws that are set because their employer is UK.
Yeah, cool. And then question that's coming from Noel about changes to the flexible working hours in terms of tracking teams. I'll just read what Noel's asked. So, do you know how changes to flexible working hours will need to be tracked for teams of thousands of cleaners that they have within the NHS every 12 weeks? Will this have to be physical evidence that we have assessed working hours and adjusted their contracted hours every 3 months? I assume that's to do with a 12-week piece.
Yes, I think the finer detail of this is yet to be determined. There were questions about whether it would be the employee or the employer responsibility to kind of report what they've been working over the past sort of 12 weeks. But at the moment, what we're aware of is that there's an obligation for employers to track that. So in some circumstances, that might be a large task. But from what we know at the moment, it's an expectation to track what an employee has worked over a kind of 12-week reference period. And then potentially that would be offered away from the 0-hour contract more as a regular contract.
Yeah, I think what's really key I've taken away from what you guys have sort of mentioned is around that process piece, isn't it? That process, how you gather that data, how you use that to your benefit as an employer, but also from that protection side as well, isn't it?
Yeah, the audit is always key.
Yeah, cool. And then I think the final question that was on here, we sort of answered around, let's say, using resources externally and managing that third-party interaction and stuff. So I think we've answered that one. So
Cool.
that's all the questions so far. Cool. Sorry.
Okay, great. Yeah, so in terms of us here at the HR department and our team, how can they support you? Well, obviously we keep handbook and policies updated as and when they happen. So we'll have come kind of March next year, we'll have a big exercise of updating everybody's handbooks and policies for our clients. And again, you know, if anybody needs any help with that, we're on hand to support with that. We can provide advice and guidance once the changes have been finalised. So as things develop, we will be obviously keeping people informed of things that they need to be aware of, and the time, you know, might be the time frames are a bit more specific or the detail of that. We can also support with training, supporting with risk assessments. I know that when we had the kind of sexual harassment update legislation this time last year, a lot of employees were like, you know, we sent out the risk assessments and employees went, oh, okay, well, how do I fill this out? You know, we know what we're looking at and we can support with that, and we can obviously talk to you about any additional requirements that you might need. We also produce fact sheets outlining key information on the changes before they're implemented, which we can share. And as HR Dept as a whole, as an organisation, you know, we are a national business kind of, so we are providing kind of feedback as well as part of like the consultation. So we're giving SMEs a voice for their concerns and feedback and opinions on the impact of the changes. So HR Dept as a whole are involved in consultation, and it's kind of feeding into that process. So it's important for us to listen to you know, to the SMEs and kind of giving them a channel for feedback on those consultations. Yeah, so this is just really just to confirm that, you know, we're here if you need us. We're here to support you through those changes. You know, we're happy to, if someone's got any specific questions or concerns, happy to have a call, set up a meeting, you know, to talk through that and how we might be able to support you. We offer lots of different types of arrangements depending on your needs. We're flexible, as we know. You know, employers' needs are different, and we're happy to tailor, you know, our services to that. I guess lastly, I think from me and Emma, just to say, you know, thank you for tuning in and to listening to us. We appreciate employment legislation updates aren't always terribly fascinating or interesting, but I think it's an important message, and hopefully you can understand the key things you need to be aware of. steps you can kind of be taking now. And, you know, if you need support with anything, you know, we're here if you need us.
I think what's really important, Helen and Emma, so thank you again for spending the time today to go through that. As you said, there's so many changes coming through. And I think, you know, the general sort of feedback we had on the lead up to this is it feels very much not in the employer's favour, like in terms of, like, therefore, obviously, some of these bits and pieces that are coming out and that will happen, as you say, there might be some adaptation to them, but they are coming. As I said, I think one of the key sort of takeaways for me from what you've sort of covered off with this is around that sort of process and the planning piece. You say that data capture, audit, stuff that like Emma mentioned within it is so important. And again, I think for the people that are on here listening and hopefully listening to recordings and stuff going forward, that process piece, we also come across that quite a lot with the businesses that we work with that may be gearing up to sell at some point in the future or looking to maximize the value and stuff on exit. Again, those bits are really important to have in place in preparation for that, if that's something that's on somebody's timeline in terms of doing. So as well as dealing with that day-to-day piece, actually that future planning piece is really important as well.
Yeah, agreed.
Yeah.
Cool. So we'll leave the Q&A open just for a minute or so, just in case there's any other bits and pieces that come through. Great, thanks, Aaron, for the feedback. That's cool. Thank you. Well, I said we'll do more of these. I said if there are things that people want covered off, obviously Helen and Emma have offered this. Obviously, the slide that we've got up at the moment in terms of, so do reach out to them if there are specifics or things that you want to sort of engage with. And like I said, really grateful for the attendance today. I say if there are other topics that you want us to cover off, then we're always more than happy to do so, whether it's around this employment piece and bringing in the HR department again to sort of go through those pieces, or whether there's things around tax and specifics around what you're doing within your businesses or personal finances and stuff at the moment. And finally, I have dropped into the chat piece, I say the link in terms of being able to sign up for the webinar that we've got set up on the 26th of November. We will be sharing that a little bit more widely as well over the coming weeks. So if you do see it, please do give it a like, a share, a bit of engagement on it. That always helps in terms of getting people along. So I'm sure if any of the rumours are to be true, there's again lots of changes that will be affecting businesses and individual taxation and finances and stuff around that. So we want you guys as our clients to be ahead of that, knowing that what you can do, plan, get your plan in place and make sure that you're in the best position to combat against any of these changes that do come. So I think, yeah, with no other sort of questions popping up, thank you again, Helen, Emma, really appreciate your time today. It's been really useful, really good input to stuff for clients. I hope it's triggered a few thoughts and engagement around that. So thank you, and we'll call this to a close. All right, thanks guys.
Thank you.
Thanks.
Bye-bye.